Our position fundamentally is that there has not been, I think they have accepted somewhat, there has not been compliance with Section 114 and Section 4.2 of the Finance and Other Reform Act, because Constitution requires certain issues in relation to public monies being deposited in the Consolidated Revenue Fund. We think the agreement does not offend those provisions.
So, in this particular instance where you were trying to make the point that this agreement should have gone to Parliament, what was the point you were trying to make there?
The point we were trying to make there is embodied in the agreement, there are some aspects of collection of taxes. And we're saying once it has to do with the collection of taxes, it should have some parliamentary sanction. Remember, this is just an agreement between the government and the other party.
Just a while ago, Mr. Coney told us that the government could have taken the option to amend the contract so that the proper distribution of public monies could have gone to the Consolidated Revenue Fund, but instead the government used its might and force to just take the company. Would you hazard a guess that the reason the government did that was that this is a Ashcroft outfit and they were trying to distance itself from that particular entity?
I will answer it in two ways. I wouldn't hazard a guess. I won't be able to answer, but what I will say is that the fact remains it was an agreement that on the face of it is in violation of Section 114 of the Constitution. Whether I entered into it or Mr. John entered into it, it doesn't change the fact that all parties ought to comply with the provisions of the Belize Constitution.